So Section 21 is very important section under the Bank Regulation Act. It says that it empowers Reserve Bank to issue directions to regulate advances by bank companies. Suppose some bank companies are giving advances on higher rate of interest, then Reserve Bank has got a right to interfere, saying that you are charging excessive rate, you should be as per the norms of the Reserve Bank. Then Section 35A empowers Reserve Bank to issue directions to regulate banking companies. Any companies are doing some unlawful activities, are opening accounts without having a proper documents, Reserve Bank has got a right to interfere. Section 36 empowers Reserve Bank to caution or prohibit banking companies generally or any bank company in particular against any transaction or class of transactions. If any accounts have been opened without a proper documents or any accounts have been opened to siphon the money or to what you call to convert the black money into white money, Reserve Bank has got a right to interfere and stop such transactions in the banking company. So let's discuss about the customer. Who is a customer? So as far as bank is concerned, the person who is having an account with the bank is a customer, or the person to whom the bank is sanctioned a loan is a customer. The person who's deposit money is a customer. So let's have a discussion on the concept of customer. To obtain legal protection, it is obligatory for bankers to satisfy themselves as regards the identity of the person, nor your customer who decides to open accounts with them. That means that a bank should be know who is the customer. They should have bank should collected the relevant KYC documents. The bank should ensure that he's a not a fictitious person, he's a true person, and he's a genuine person. If the bank thinks that if when the customer documents are void, the bank has got right to refuse the registration of opening of this account, and the matter should be informed to the enforcement agencies. Now, a lot of frauds are being happening. So many fraud accounts are being opened. So there, the banks should be very careful while we are opening the accounts. Know your customer guidelines issued by Reserve Bank require banks to follow customer identification procedure for opening of accounts and to monitor transactions of suspicious nature for reporting money laundering activities and combating financial terrorism. Now you know that terrorists are using the bank's channel for diversion of these funds. They will illegal money which has been procured from different sources will be routed into the bank channel and will be sent to the beneficiaries. So Reserve Bank is a very strict that banking channel should not be used for financing of terrorism. So that is why KYC has become prominent. A bank which is not following the KYC has to be will be penalized. And if you link it to the different protections given to a banker under the NI Act and other acts, you have to comply with the KYC. Then only you will be able to get a protection under the various laws. Take the case of NI Act, Section 131 of NI Act. It says that a banker who had in good faith and without negligence received payment for a customer of a check crossed generally or specially to himself shall not, in case the title to the check proves defective, incur any liability to true honor by reason of only having received such payment. Suppose uh, an account was opened in a branch and some checks he deposited in the account which is sent for collection. And bank received the money and dispersed to the customer. Later on, it found that check was a false check. So, to get protection, the banker should ensure that the account opening forms are properly done by the branch. If the account opening is not done, that means the KYC documents are not properly procured by the branch, then bank will not get the protection under Section 131. That means the bank who has collected the documents will be responsible for the loss. So, in order to get any protection under the statutes for a banker, the banker should ensure that KYC documents and all relevant documents have been collected at the time of opening of the account. If it's a company, they should have obtained the certificate of registration from the ROC, relevant articles association, article memorandum association. All these things has to be collected while opening an account. In case of a trust, you should have a trust deed. You should have resolutions. In case of society, you should have bylaws. You should have resolutions. All these things has to be collected by the banker before opening an account. If any account is opened without having these details, then banker will be ultimately responsible for the loss occurred to the concerned persons. The banker is under obligation to keep secrecy of account details of the customer. That is very important. Uh, it is responsible of the bank to ensure that the account details of the customer are not divulged to any person without having a proper legal remedy, without having a proper legal provision. Suppose somebody, your neighbor, want to know what is the amount in lying in your account. So he filed an application under RTI. And if the bank gives the details, the bank will be responsible because bank is under obligation to keep the secrecy of the accounts of the customers unless it is called by the statutory or the other responsible officers. Suppose police is asked about the financial details of a person, the bank has to give it. So court is asking to produce a statement of account of a particular account, bank has to do it because it is a call from the statutory or law enforcement agencies, bank has to comply with. But any third person asks about the details of a customer, the bank is under obligation not to disclose it. Now the relationship between a bank and depositor, bank and borrower. If you are a depositor in an account with the bank, then you are a creditor, bank is a debtor. That means the money, bank owns the money to you if you are a depositor. But take the case of a borrower. In the case of borrower, the borrower is a debtor and bank is a creditor. Bank has sanctioned loan to him. He is under obligation to repay the money back to the bank. So this is what the debtor and creditor relationship between the bank and customers. And bank is also acting as an agent of the customer to collect customers' checks, credit instruments like dividend warrant, interest warrants, pension bills, etc. The banks are doing a lot of work as an agent of the customer. Suppose the if your account, salary account is maintained in a branch bank, then your organization, you are suppose you are working in a secretariat, your government secretariat, then the money the government will give credit to your account. So you are the banker is acting as an agent of you, the salary of you and crediting into your account. So these are the instances where bank is acting as a agent of the customer. Now the as I already mentioned, the secrecy of a customer's account. It's obligation of the bank to keep the secrecy of the customer's account. Banker should take scrupulous care not to disclose the state of his customer's account. This actually there is a case in England. It's called Tausier's case. It's happened in 1924. There the court has passed an order that bank is under obligation not to disclose the financial details of a customer. That has become customary in all the banking sector, and in India also banks are very strictly keeping the financial details of the customers very secretly, not disclosing anything to a third party. So banks must not disclose the condition of its customers' account except on reasonable and proper occasions, and the obligation to observe secrecy does not end even with the closing of the customer's account. Somebody may think that once the account is closed, then bank does not have a responsibility. It is not like that. If the account is closed, also bank is under obligation unless and it is called by the statutory or law enforcement agencies. And so many banks has got their own rules and regulations where they make it clear that the customers' secrecy should be maintained. Take the case of State Bank of India, Section 44 of State Bank of India Act 1955 says that State Bank shall observe, except as otherwise required by law, the practices and usages customary among bankers, and in particular, It shall not divulge any information relating to or to the affairs of the of its constituents. Constituents means the customers, except in circumstances in which it is in accordance with the law or practice and usage customary among bankers, necessary or appropriate for the state bank to divulge such information. So unless and until it is permitted by law, you cannot disclose the details of the customers to any other person. If it's called by the court, if it's called by the police, if it's called by the Central Bureau of Investigation, you can disclose it. Otherwise, you should not disclose the details to any other person. Nothing contained in this section shall apply to the credit information disclosed under the Credit Information Companies Regulation Act 2005. You know that a lot of credit information companies are there. Sibyl is there. So many other agencies are there where they are giving a score to the customers while they're approaching for the loan. So for Sibyl score, of course, there is an exception. That means there is a government has given permission to Sibyl to collect the financial details of the customers from different banks. So on the basis of the financial details, Sibyl is maintaining a score. If your repayment is good, there is no default from your side in repayment, then you will get a very good civil score. So that will help you to take small loans from the banks. If a civil score is less, that means that you have a lot of default. Then banks may be reluctant to sanction a loan to you because you have a tendency of repayment, default in repayment. Now, the customer's account exemption is there under Section 94 of the Bharatiya Nagarik Suraksha Sanhita. It says that whenever any court or officer in charge of a police station considers that the production of any document, electronic communication, including communication devices, which is likely to contain digital evidence or other thing, is necessary or desirable for, for the purpose of any investigation, inquiry, or trial or other proceeding, may by a written order, either in physical form or electronic form, require the person in whose possession or power such document or thing is believed to be to attend and produce it or to produce it at the time and place stated in the summons and order. So police or court can issue a notice to summon this document under Section 94 of the Bharatiya Nagarik Suraksha Sanhita. So when a notice is received by the bank is under obligation to produce these documents for the court. So only these cases only these exceptions only, bank will disclose the details, customers' details. Other cases, the bank is under obligation not to disclose it. Now, there is a Deposit Insurance and Credit Guarantee Corporation Act is there. Where on the basis of this one, DICGC has been constituted. DICGC is a subsidiary of Reserve Bank of India. The main purpose of this organization is to provide insurance to deposits in banks and to give a guarantee on loan facilities for the banks to a selected class of society. That means that you are if you are deposited with the bank, then it is guaranteed by the DICGC. Up to 1 lakh, your deposit has been insured. So if any losses happen to from side of the bank, you have get an insurance scheme, insurance facility of up to 1 lakh in case of your deposits. The deposit insurance scheme is mandatory for each bank currently present in India. So this DICGC Corporation maintains three different types of funds, namely the Deposit Insurance Fund, Credit Guarantee Fund, and General Fund. The Deposits Insurance Fund is maintained through insurance premium obtained from the banks, and the credit guarantee funds are maintained from guarantee fees received at the time of granting or not. So all banks are giving premium into this for deposit for giving insurance to deposits. And you will be knowing that CGIT, one scheme is there where the bank government is giving loans to different persons. Banks are giving loans to different eligible persons, and if there is a default, the central government will repay the loan to the bank. So these are the credit. These are all credit guarantee schemes. Suppose in the default, if borrower fail to repay it, the government will guarantee or government will repay the money back to the bank. So this is what we called a credit guarantee fund. And deposit insurance means if there is a loss in the deposits of any customer, it will be repaid by this deposit insurance corporation. And there is general funds have been maintained by this corporation. That is only for the for administrative expenses of the corporation. So all deposits such as savings, fixed, current, recurring, etc., normally issued by DICGC, except for the deposit which are specifically mentioned. Rupees 1 lakh is the maximum amount which is insured by DICGC for each user on deposit amount as well as the interest. So normally your deposits are insured for 1 lakh only, but I think in almost all cases, banks are able to repay the full amount in case of difficulty also. But to an extreme case, if the banks have been liquidated, then I think your deposits up to 1 lakh has been insured by the DICGC. If the bank goes into liquidation, then the DICGC will pay the insured amount to the depositors or the official liquidate upon the Reserve Bank of India. So, Prevention of Money Laundering Act 2002 is very important because banking is a channel where the terrorists are using for encashing their, for washing their black money into white money. So that is why Prevention of Money Laundering Act has a lot of applications in banking sector. So, Prevention of Money Laundering Act, the purpose is to prevent money laundering and to provide for confiscation of property derived from money laundering. So, wherever the money is involved in terrorist activities, the government has got right to confiscate this money and take back money from the banking sector, banking channels. PMLS seeks to combat money laundering in India and has three main objectives: to prevent and control money laundering, to confiscate and seize the property obtained from the laundered money, to deal with any other issue connected with the money laundering. So, money laundering is basically converting the black money into white money. So the terrorist group which are which are taking out the money from illegal activities, they will push that money into the banking channel and it will divert into beneficiary as a normal banking business. So to prevent all these things, Money Laundering Act has a lot of provisions where the government has got a right to confiscate and prevent these type of activities. The Act prescribes that any person found guilty of money laundering shall be punishable with a rigorous imprisonment from 3 years to 7 years, and where the proceeds of crime involved relate to an offence under the NDPS, the maximum punishment may extend to 10 years instead of 7 years. So, PMLR says that the punishment is between 3 to 7 years, but if the punishment is led into NDPS, that means any narcotic drugs is related to any transaction is happening related to narcotic drugs, then the imprisonment may be up to 10 years. The director or officer above the rank of deputy director with the authority of the director can provisionally attach property believed to be proceeds of crime for 180 days. Such an order is required to be confirmed by the independent adjudicating authority. So wherever the money has been any money has been made out of this sale of narcotic drugs, then central government has a power, director has got a power to attach this money and confiscate this money. So there will be an adjudicating authority. So primarily they will issue a provisional attachment order on after confirmation from the adjudicating authority. The money will be permanently taken confiscated by the central government. The person who is accused of having committed the offense of money laundering has to prove that alleged proceeds of crime are in fact lawful property. So the burden to prove that the money is not from the alleged or unlawful activities, it is burden is on the concerned person, concerned accused only. Normally in CPC or in our criminal system, the burden is on the other person to prove that he has committed an offense. But it is otherwise, that means it means the accused has to prove that the money is not from the illegal sources. An appellate tribunal has power to hear appeals against the orders of adjudicating authority. So, against the order of adjudicating authority, there is an appellate tribunal. Appellate tribunal will decide upon the appeals. Orders of tribunal can be appealed in appropriate high court and finally to Supreme Court. So, appellate tribunal orders will be challenged, can be challenged before the high court. Thereafter, it can be challenged for the Supreme Court. And Financial Intelligence Unit India, FIU Inc., is very important role to play in controlling the illegal activities in the banking channel. FIU Ind was set up by the Government of India on 18 November 2004 as a central national agency responsible for receiving, processing, analyzing, and disseminating the information relating to suspected financial transactions. FIU Ind is also responsible for coordinating and strengthening efforts of national and international intelligence, investigation, and enforcement agencies in pursuing the global efforts against money laundering and related matters. FUE is an independent body reporting directly to the Economic Intelligence Council and by the Finance Minister. So FIU Indism is a arm of the central government where they are controlling, they are monitoring all the suspicions transactions.